The Supreme Court of Ohio considered several important legal issues when it conducted oral arguments in October. The court heard 15 cases in total. The justices traveled to Defiance County for a special session of off-site court, where more than 1,800 students were able to view the Supreme Court at work. At Defiance High School, they considered challenges to an Ohio gun possession law and the legality of a traffic stop involving a canine sniff to detect drugs. In 2022, Elijah Striblin was carrying a concealed pistol when he entered the Lazy River Lounge. Bar video showed him ordering 2 drinks and taking a sip of one of them. Later that night, he got into a fight with another man at the bar and shot the man in the neck. Among other offenses, Striblin was charged with violating an Ohio law that prohibits the possession of a firearm in an establishment with a liquor permit. He pleaded no contest, but argued the law violates his right under the Second Amendment of the U.S. Constitution. The 5th District Court of Appeals agreed with Striblin, finding the 2022 Bruin decision by the U.S. Supreme Court only permits firearm regulations firmly rooted in our nation's history and tradition of gun regulation. The court found the state law didn't meet the historical standard and was unconstitutional. The Muskingum County Prosecutor's Office appealed.
And what Bruin did is say, yes, states and the federal government, you can regulate firearms. But to do so, your regulation must fit within this nation's tradition of firearm regulation. So the question before this court, the ultimate question before this court is, can there be a tradition, or is there a tradition, of prohibiting firearms into bars?
So isn't the question in this case really whether we have a tradition of disarming people who are intoxicated when they come into bars?
So as of now, when other courts have looked at this question, they have come to the conclusion that laws more sweeping than Ohio's, that are outright prohibitions on places that serve alcohol, you can't bring any firearm. Ohio doesn't have that much sweep.
The men who fought in the Revolutionary War would meet in taverns and public houses with their firearms and go over battle plans while enjoying a beverage. Same with the Civil War. So how is this a sensitive place?
Yes. In 1791, at time of the enactment of the Second Amendment, drinking was widespread. During the Revolutionary War, the Sons of Liberty would meet at taverns and they would carry firearms. And I think that would cut against the state's position here. But when you look at Bruin, I would say that 1791 is not the exclusive place we look at in history. There are many things that you can see refined over time that were within the tradition that the people who enshrined the right to bear arms understood that they could do, that they could regulate. I think the essential part of this case is Americans who enshrined the Second Amendment, Americans who enshrined the 14th Amendment, that they had gun regulations themselves.
Striblin's attorney was questioned about her client's challenge to the law. Striblin did not bring a challenge limited to just how the law applied to him. He had a license to carry a concealed weapon and claims he wasn't drinking alcohol, but said the law is unconstitutional because Ohio considers any place with liquor licenses to be sensitive places that can limit the possession of a gun.
So I guess I'm a little perplexed by why you didn't bring an as-applied challenge rather than taking on this burden of having to show that the statute is unconstitutional in every possible application.
What's particularly noteworthy about the language used in count 2 of the Striblin indictment is there's no allegation that Mr. Striblin was intoxicated at the time in question. The state did not allege that Mr. Striblin, at least not in the indictment, didn't allege that Mr. Striblin was intoxicated. The case presents only a question about, we state, sensitive place regulations. It's important when analyzing such Second Amendment challenges to remain mindful of the Supreme Court's caution against construing too broadly the category of sensitive places, such as schools and government buildings, as it would eviscerate the general right to publicly carry arms for self-defense.
In a second case, the court heard John Kincaid's challenge to his drug trafficking conviction. In 2019, a Meigs County deputy observed Kincaid's vehicle crossing a road's center line and pulled him over for a traffic stop. The deputy was a canine officer and had his dog in the cruiser when he pulled Kincaid over. The officer had never met Kincaid, but had information from the community that he was involved in drug trafficking. The deputy called for backup because Kincaid had a passenger in the car and decided he was going to have the dog sniff for drugs. While waiting for other officers to arrive, the deputy asked a dispatcher to search the criminal history of both Kincaid and his passenger. Neither of them had any warrants for their arrest. The deputy did not issue a traffic ticket, but the dog sniff led to the officers finding illegal drugs. Kincaid claimed the search violated his rights under the Fourth Amendment to the U.S. Constitution against unreasonable searches. The Fourth District Court of Appeals upheld his conviction and found the search to be legal. Kincaid argues to the Ohio Supreme Court that under the U.S. Supreme Court's Rodriguez decision, a person's detention at a traffic stop cannot be prolonged to wait for law enforcement backup before conducting a canine sniff.
But the dog sniff's not a search, right?
The conduct.
So does the same rule apply to the dog sniff?
Yes, because the traffic stop became unlawful when Deputy Campbell turned this into a drug investigation, and the question is whether the duration of the stop was constitutional.
The justices questioned the state's attorneys on whether the officer was still doing administrative tasks while waiting for backup. The state argued that the time it took to check on Kincaid's criminal history did not prolong the stop.
That's why he wanted the drug sniff, right?
Oh, that's absolutely
He admits
correct.
that I just knew this guy from the community.
Right.
So that's why I'm going to do this.
We can set that aside because we know from Rodriguez and Caballas that the dog sniff isn't a search independently. So you don't have to have a reason, much less a good reason, to run a dog sniff at all.
I would agree. But
Right.
we're talking about extending a traffic stop.
Right.
And the only reason we're doing this, based on his own testimony, is his belief of who this individual is in the community.
So because the traffic stop wasn't extended in violation of Rodriguez, we don't need a separate probable cause for the dog sniff.
You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments in Columbus, with each session beginning at 9 a.m. You can also see them live online at supremecourt.ohio.gov.